Well, good morning, everybody. Hope that you can hear us. Thanks for joining us this morning. We're just going to maybe give it 2 or 3 minutes to let some people join us as well. But whilst we're doing that, let me just go through some housekeeping stuff, if that's okay. I'm joined this morning by my learned friend, Nick Smith. I'm sure most of you will know Nick.
Good morning.
Welcome, Nick.
Good morning. Thank you, Geraint. I'm very lucky that I've got my favourite on my right-hand side, my favourite right-hand man, Mr. Geraint Probert. So thank you. But you want to carry on with the introduction before I carry on rudely interrupting you,
No,
Geraint?
that's fine.
Crack on.
That's fine. Just a couple of housekeeping bits. I'm sure that you're all very confident and competent when it comes to Microsoft Teams meetings by now, but just a couple of reminders. In terms of bandwidth, that word that we didn't know about really before COVID hit, but bandwidth and the importance of having good connection. If you're struggling, turn your camera off. That's usually a good way of maximizing the power that's coming through to your machine. So if you're struggling to see us and or hear us, try flicking off your camera. That might assist. Secondly, if we can ask you to mute your microphone, because that will, otherwise there'll be feedback and muffled sounds and it'll be a bit embarrassing. So if you can just remember to mute your microphone. In terms of questions, we're very keen to answer any questions. The neatest way to do that is at the end, because we're conscious that, first thing in the morning, people do need to head off and get on with their day. But if you'd like to stay and ask any questions, then absolutely, please do hang around at the end. We'd be happy to cover any of those. The easiest way to do that is to probably type out your question in the chat function. Again, if you hover your mouse over your screen, you should see a tab which says chat, or I think it might even be called conversation. Actually, yes, it's called conversation on MS Teams. So click on that and you'll be able to type in your question and we'll do our best to answer it at the end rather than interrupting the flow as we're going through, if that's okay. Another quick bit of housekeeping is to say that we are recording this session this morning. So that's just to make you aware of that, basically. So I don't think there's anything really else we need to go through in terms of housekeeping. Like I said, any questions, we'll cover them at the end. If you can remember to have your camera off and your microphone on mute, that's probably going to be best for everybody. Oh, there's one more thing, which is to do with the PowerPoint slides, which you hopefully will see on the screen. At the moment, it says Breakfast Bites with Nick Smith and Geraint Probert. Please refrain from the temptation. I know it's a big temptation to take control of those slides and flick on to the bits that you're interested in. Please don't do that, because it'll basically mean that we can't control the slides. So as tempting as that might be, please don't do that. And secondly, please don't also share your own screen, because otherwise we might have to send you an email after this with a GDPR. So I hear myself coming through someone. Make sure that your microphone and your speakers, sorry, not your speakers, otherwise you won't be able to hear us. Your microphone is muted, then that would be fantastic. So let's make a start. I'm going to hand over to Nick.
Right, chaps. Just make sure everyone can hear us okay. Can someone just let us know if there's a problem hearing? Right, I'm going to talk about, my section of the talk is going to be on causation and asking the question, what is the reason why something happens? Which frankly, the most important question. Right. Sorry, we've got somebody. Speak that's great. Can we make sure everyone's muted, please? Because otherwise we'll have terrible feedback. And I'm not talking about afterwards, I'm talking about now. All right, so I'm going to be dealing with the first two cases here, Sinclair and Trackwork and Kong Gulf International, which are two cases that were highly relevant to a case I've just finished, a very long case I've just finished on whistleblowing. I thought, having included those in my skeleton, it might be quite good to use that information whilst it was still very fresh. So I'm going to deal with that to start with, if I may. Geraint's going to take you through the rest of those cases, I think at relatively good pace, but let me just deal in a little bit of detail with a couple of the key issues. So the title here, it's not what you do, but the way that you do it, reminds me of that Bananarama song from the 1982. I think they were joined by Funboy 3. Those of you who are, as many of you will be, far too young to have even been born at that point in time, have no idea what I'm talking about, but there's a certain jingle that springs to mind when I hear that song. Okay, so what is the true cause of a dismissal in an automatic unfair dismissal case, or where you're relying on 103A dismissal for whistleblowing? And the starting point for me, and this also applies to victimisation claims under the Equality Act as well. You'll be very familiar with Bolton School and Evans. It's the case where you had the employee of the school who considered that the system, the IT system, was insecure, went to extraordinary lengths by hacking into the system to demonstrate that it was insecure, and went to the extent whereby he secured data and decoded data relating to personal passwords, for example, before he was given a written warning by the organisation, not for the information which was disclosed, which was, in brief, your system's not very secure, but the way he went about communicating that information. And that's really where you get the expression, it's not what you do, but the way that you do it. And that's one of the best cases in that entire arena, as a simple example of what we mean by separating out the message from the way in which the message is delivered. You'll be familiar also with the case of Martin and Devonshire solicitors. Remember, this is the case in 2011 where we have a secretary in a solicitor's firm who has, she's accused several senior members of the firm, one in particular, of sex discrimination. She's alleged that one of them has called her a prostitute, amongst other things. That's led to an investigation. The investigation drew a complete blank. And it, as part of the overarching investigation, the organisation decided to ask her to go for an OH review. She saw an occupational health consultant, and he made it very clear that at the time of the allegation, she was suffering from depression, and that and a feature of that depression was psychosis. And as a consequence of that, they decided that she needed to be dismissed because she represented a significant concern to the organisation. The point being, she wasn't being victimised for having raised these concerns. They were enabled to separate out those considerations, and there were three factors that were separate from the complaint itself that led to the fairness of the dismissal. Firstly, was the falseness of the allegations. The fact that the appellant was unable to accept that they were false was the second one. And the fact that both of those features were a result of mental illness, and that presented an ongoing risk of further disruptive behaviour to the organisation. So the Employment Appeal Tribunal under Mr. Justice Underhill, as he then was, gave a very helpful synopsis of this basic principle. Going back to cases in 1976 and then one in 1995, which is the Bass Taverns and Burgess point. And effectively what he said was the most straightforward example of this is where the reason relied on is the manner of the complaint. Take the case of an employee makes in good faith a complaint of discrimination, but couches it in terms of violent racial abuse of the manager alleged to be responsible, or who accompanies a genuine complaint with threats of violence, or who insists on making it by ringing the managing director at home at 3 o'clock in the morning. Those are three examples he gave as being separate and separable from the message itself. He said this: in such cases, neither artificial nor contrary to the policy of anti-victimization provisions for the employer to say, I am taking action against you, not because you have complained of discrimination, but because of the way which you did it. So he gave further examples, for example, where the messenger uses intemperate language or inaccurate statements. And he makes the distinction between the subtle difference between a very gross, excessive use of language, for example, or a threatening behavior, from just a simple slight exaggeration, misuse of language, or use of intemperate language, which is not properly separable from the message itself. So that takes me on to what I think is the high watermark in this line of jurisprudence, which is the Woodhouse and West Northwest Homes Leeds case in 2013. Now, John Hand was sitting in the EAT in this matter. This was a case involving a black employee who complained of racial discrimination in the form of inappropriate language used in his direction. He then raised further grievances, 10 in total, but those grievances included, for example, things like the failure by the organisation to deal properly with his grievance, victimisation arising from his grievances, and further acts and complaints that were made. The Employment Tribunal decided that there was a separability, as it were, between the complaint itself and the manner with which the complaints were raised. The employer in this organisation took the view that because of the number and the unsubstantiability of the complaints that were raised, that they were able to dismiss him on the grounds of a breach of trust and confidence and an SOSR. And that led to a very careful analysis by the AT of quite how you go about making the separation between the message and the reason for the dismissal being different from the message. I use the word message because, of course, it's a broad term that we can use in respect to victimisation claims as well as whistleblowing and discrimination matters. So he looked at the particular allegations that they relied on to say they were separable, and allegations that the grievances were unfounded, for example, that they were scattered around. There was a machine sort of scattergun approach, repeated pattern of accusations that turned out to be false. And he said this: the process of measuring cases against such a yardstick is a dangerous one. One person's conviction that they have been discriminated against is very likely to generate the polar opposite, i.e. that the complaint is irrational or about the person or the organisation complained about. Experience of this type of litigation teaches that grievances multiply, so the fact that there are a series of them is not unusual. It is a slippery slope towards neutering the concept of victimisation if the irrationality and multiplicity of grievances can lead as a matter of routine to the case being placed outside the scope of the legislation. And that's very, very common scenario. Certainly, that's a big feature in the case I've just been dealing with, where you have a multiplicity of complaints raised by a determined whistleblower who isn't letting go, who is like a dog with a bone, and who is somebody who is pushing forward and not letting things slip time and time again. Does that cause dysfunction? Well, it may well cause dysfunction in an organisation, but is that properly separable from the source of complaint itself and the complaints themselves about, for example, breach of legal obligation or health and safety? So this was a case where His Honour Judge Hand QC, when sitting in the AT, was making the point that it would be an exceptional situation if you were able to separate those matters in these sorts of cases. And there's a follow-on case called Paniatu, which decided that that was placing the bar too high. But that's all really a background to the two cases that I'm going to talk to you about this morning. The first is Sinclair and Trackwork. And this is really a question, again, of whether you can place a gap between the message or the activity and the mode of which that message or activity is communicated. This is a Section 100 ERA claim for health and safety dismissal. And in this case, we have a track work employee who is engaged to enforce a series of new regulatory obligations that are being placed in the railway world. And he is told to go and enforce the new regulations effectively. The manager says that he'd like him to adopt a softly approach to doing that, but didn't in fact communicate that to this unfortunate chap, who ended up going about his work with a degree of zealous and careful execution of a role. But the fact is that his colleagues who he was seeking to manage change, and there's a term we hear all the time in HR world, management of change is a very complicated thing. the managers hadn't told his colleagues that these new regulations were coming in and that he was going to be charged with enforcing it. So what then happened was they fall out. There's a degree of dysfunction at work, again, because there is an issue here about the way in which he is executing his duties and what they describe as an overzealous execution of the role. And Mr. Justice Chowdhury, the president in the EAT, dealt with this. And he gave some very clear guidance on the sorts of cases where you can properly separate one from the other. I'm just going to take you briefly through some of the findings and some of the conclusions he reached in paragraph 22 of his judgment. It's an important decision. He said, firstly, as a matter of causation, matters identified by the tribunal as being the reasons for the dismissal are the direct result of carrying out by the claimant of his health and safety activities as a designated employee. It was the claimant diligently carrying out his activities that caused relations with his colleagues to sour. Those relations had not soured for some other reason, which might have intervened in the chain of causation between carrying out the health and safety activities and his dismissal. And the point here I think he's making is that there's no evidence that he was excessively hard-nosed with his colleagues, was using abusive language, was bullying them or anything like that in the execution of his duties. He then went on to say this: the souring of relations or the overzealous manner in which the claimant carried out his duties are not matters which can be said to be properly separable from the carrying out of those activities on the facts of this case. The claimant, as the tribunal found, was merely doing what he was instructed to do. The tribunal did not find the claimant had exceeded the terms of his mandate in implementing NR 109, which is the regulatory change. Rather, it was the claimant colleague's perception of those activities being overzealous that caused the friction and the souring of the relations. He then went on to say, this is not a case which can be said, he's relying on a case called Goodwin, that the claimant carried out his activities as a designated employee in a malicious or extraneous way, so as to deprive him of the protection afforded by the Act. And what happened here was that, having instructed this chap to go about these duties, which are onerous, they then fired him on the grounds that he had fallen out with his colleagues, or more importantly, his colleagues have fallen out with him, and that there was a good reason, therefore, terminating his contract of employment. Now, that's the sort of case that you find quite rarely. What we're dealing with quite often, particularly in things like big organisations like the NHS, for example, is you deal with quite often a situation where you have someone who says they're blowing the whistle and they're dealing thereafter with the dysfunction that arises from that in high pressure working environment. I'll take you on now to the case of Kong, if I may, and then I'll be handing over to Geraint. But obviously, all of these cases hinge on their own facts. What you have to have mentally in your mind is the ability to separate one from the other. So in the FESIC case, which you'll be very aware of course, dysfunction in the NHS was the reason given for dismissal. Is dysfunction itself sufficiently separated from the underlying causes of dysfunction that it can actually be properly separated away? It's an interesting question of law, by the way, that one, and yet to be properly looked at, I think, by the Court of Appeal. But we'll come back to that a bit later on. But looking at the next big case in this line, which came out during the course of my recent trial, the case of Kong. Again, we have, although it's not used in the language isn't used in the specific way, I've given you a bit of detail in the slides, so just take a quick moment to review it. But we have a situation here where we have two relatively senior people in an organisation. I won't go into the details because they're quite complex in terms of what was alleged. But we've got the head of financial audit and the head of legal going toe to toe in respect of the financial auditor's review of a legal document prepared by the head of legal. She isn't happy with it. She thinks it is potentially unlawful. And it's the way she goes about dealing with it that's the root cause of this litigation, because she goes and effectively informs the head of legal that she didn't think she was very good at her job. She didn't think she had sufficient legal awareness. the head of legal got extraordinarily upset about this, refused to enter into discussions or mediation with the head of financial audit, and there's a really serious falling out. The initial interplay between the head of legal and the head of financial audit, had that claim been brought in time, would have been an act of detriment under 47B. But because that claim wasn't brought in time, there was no finding in her favour. The real question is whether the decision-making panel, which comprised 3 very senior people in the organisation, so that's the head of HR, CEO, and group chief auditor, whether those 3 people, who then got together and decided whether or not the relationship was so broken that the best thing they could do was to fire the head of financial audit, which they then did. They did it unfairly under 98.4, but that the tribunal found very carefully that they were able to separate away the fact that she had given information tending to show breach of legal obligation under 43(1)(b) from the fact that she, in fact, had been the subject or the root cause of a major falling out between 2 very senior people in the organisation who they decided to get rid of. This case also raises another example, and this is a talk for another day, and I certainly would really relish the idea of setting aside an hour for this at some point. This case also deals with the follow-on from the duty case, and it's another example of the many that are multiplying week in, week out about the ways in which an organisation can properly say, yes, there may have been some retaliatory behaviours, but the decision-making panel itself wasn't tainted by that thinking at the time of making the decision. So that's maybe for another breakfast bites in the near future. But that's me done for the time being. I think I've taken up plenty of time this morning, and I'm looking forward to Geraint cracking on with some really, really other exciting cases. But thanks for your time. Any questions on either of these 2 cases or any of the preceding ones I refer to, let me know later. Speak to you later.
Yeah, great. I mean, just my thoughts on Kong. I think I agree, Nick. It's a really interesting case. I think this area of law is still to find its true development in terms of where it's going. So you've got Jehuti and you've got Osperov as well, where you can allege detriments against individual players in a decision-making process as well. So I think that Kong, deserves more time. Maybe we'll flag it up and maybe we'll pick it up later in the year or maybe at the beginning part of next year, see how things develop from this as well, and whether or not there might be an appeal going higher as well. But let's move on from that, and I'm going to grab hold of the PowerPoint presentation here to take you to the first of my cases. This is Martin and London Borough of Suffolk. Thank you very much. The issue in this case is protected disclosure. So it follows on quite nicely, really, from Kong, talking about protected disclosure dismissal. This was a protected disclosure detriment case. And what we're going to be looking at is section 43B, subsection 1, as we all know. What was it that made it a qualifying disclosure? This is a judgment in the EAT from June from Judge Taylor. I don't know if you've come across Judge Taylor in your own practice. I have on a number of occasions now. I always like his judgments. He has this knack of being able to analyse the law very clearly and systematically, but also it's very readable. So I recommend Judge Taylor. If you come across one of his judgments, then it's worth really getting stuck into it because it's good stuff generally. Now, this is a case whereby the claimant was a teacher, and the basic essence of his disclosure that he alleged was qualifying was that he was concerned, and there's that word that raises alarm bells, concerned that teachers, including himself, were working in excess of, in his words, the statutory directed time. Next slide. Now, the starting point, of course, is going to be, as Judge Taylor says, the statutory wording of section 43B itself. Before we jump into the case law, that's where we have to start, the statutory wording. Now, the tribunal's error in this case was that essentially it was loose. It was loosey-goosey in the way that it analysed the question of whether the disclosure in play was qualifying or not. And Judge Taylor reinforced the quite well-known 5-step analysis now. But Judge Taylor goes further than that. He says, look, this is an absolute requirement for tribunals. Let's have a look at what the 5 steps are. They're on the screen in front of you, and I've bolded them out, so hopefully it's easier to see. First, there must be a disclosure of information. Now, just pausing there quickly, the concern on the one hand and disclosure of information, we know, is going to be a fighting point potentially if information is couched in terms of a concern. We'll come on to that in just a moment. Secondly, the worker must believe that the disclosure is made in the public interest, so a subjective belief. And then if the worker does hold this is the third point, it must be reasonably held. So it's that marriage between subjective and objective belief. Fourthly, the worker must believe that disclosure tends to show that one of the matters listed, A to F, that there's a breach or an infringement on those categories. And fifthly, the worker does not, if the worker does hold that belief, it must be reasonably held in that as well. So that's where objective analysis comes in as well. So a belief in the truth of what is disclosed, and also that it tends to show one of those things. And that's a marriage between subjective and objective understanding. And that's quoting from Judge Auerbach in Williams. Now, this is where we need to really emphasize the point in Martin. This is what Judge Taylor says in terms of quoting Williams in the analysis of the law that Judge Taylor provides. Unless all 5 conditions are satisfied, there will not be a qualifying disclosure. And in any given case, any one of those might be in dispute. And we know that from practice, don't we? But in every case, this is the underlined bit, it is a good idea for the tribunal to work through all 5. Pausing there, I know that that's couched in terms of it being a good idea, but this is pretty clear authority from the EAT that as a tribunal, you've really got to be doing this. And I don't know what good idea you'd have to not follow this 5-stage process, but this is a good idea. So I think we've got to take that for what it is. Now, the criticism really of the tribunal in this case of Martin was that, like I said, they were too loose with the analysis. They sort of went on gut feel as to whether or not the disclosures were qualifying. And the judgment, this was a 4-day hearing and 3 days of deliberation before the tribunal made findings that none of the disclosures were qualifying. But the judgment was 10 pages long. Now, Judge Taylor, again, in his style, says there's nothing wrong with being concise. That's to be applauded. But this is too concise. This is too short. 10-page judgment for a 7-day hearing, effectively, not enough. Loose analysis. So the bullet points really are the importance of this structured approach. But then there's a further point which reared its head in this, which is what we mentioned a moment ago about the concern and whether that really was information. This is always going to be a knotty issue because most whistleblowers or potential whistleblowers do not understand the statutory hula hoops that they need to jump through in order to get something as qualifying at the end. It just sort of happens, doesn't it? There's often a lot of emotion involved. There's a lot of psychology involved when it comes to whistleblowing, which is well documented and well researched. So what is information as compared to a concern? Again, this judgment is a good one to have a look at, just sets out what I would describe as a common sense approach, but not an overbearing threshold either. It's not a low threshold, but not an overbearing threshold. It's got to have sufficient factual content and specificity, easy for me to say first thing on a Wednesday morning, to be capable of tending to show one of the matters listed. So there it is, bullet point. I'm not going to attempt to say it again before I have another coffee, but it's about that specific factual content that is enough to show one of those materials, one of those matters, I should say, listed through A through to F. So that's helpful as well. Let's move on to the next case. This is Falahahi and TWI Limited, a judgment of Mr. Justice Bourne in the EAT from August this year. And this is an unfair dismissal case. And the reason for dismissal was capability. The interesting thing about this case was that the appellant in question, the claimant, the employee, was under a final written warning when the dismissal decision was made. So there's a starting question, which is that because this wasn't a conduct dismissal, was a final written warning going to be as relevant as it would be in the well-known authority line of cases when it comes to written warnings in conduct matters? So we'll have a look into that in just a moment as well. I should also stress that the warning in question was not a conduct warning. It was a performance type warning as well. So all of that interplaying. Let me give you a little bit of the background in terms of the facts. So the appellant was employed as a project leader, and issues were raised about his performance in around January 2016, there was an initial performance management process commenced. Objectives were set to be measured at 3 times within that next 12-month period. So you got January 2016. The first analysis was going to be in June of that year, 2016, followed in October and then January to sort of finish up a 12-month period of review. Now, the interesting thing about this within the internal workings of the employer was that before the first sort of date in June to review came along, in May, the manager that was looking after the claimant in this case realised that not really any progress had been made at all. The first review was just round the corner, but there was nothing really happening to encourage the manager looking after the claimant that progress was being made. So long story short, a capability hearing is set then in May, the end of May, 26th of May 2016, at which a final written warning was given about performance. That had a 3-month review tagged onto it. So there we are, clear picture. Employee knows from the 26th of May, final written warning, and he needs to improve within 3 months. Unfortunately, as can sometimes be the case, as we know from practice, the claimant didn't cope well with that sort of pressure, went off on sick from the July, didn't really have the opportunity to do much more than that, because then by the time the November came around, he was given notice of dismissal on the grounds of capability. In terms of that dismissal letter, the wording was very clear that it was on the back of the final written warning. So the questions really for the tribunal in terms of dismissing the claim it was asserted on behalf of the claimant that final written warning, well, 2 things. First of all, it wasn't given in the correct sense. And secondly, it was inappropriate for capability proceedings anyway. Let's deal with the second of those issues first, about whether it was inappropriate in terms of a capability process. Let's have a look at the dismissal letter, which set out the following, and I'll read it to you. It's not on the slide. It said, following the receipt of the final written warning on the 3rd of June 2016, which I note you did not appeal, again, red flags for us there as employment lawyers, not appealing a previous warning. But anyway, given your continued underperformance and the apparent lack of understanding on your part as to what is required of you and how to achieve the level of performance that is expected as a project leader, despite clear achievable targets having been set as part of the process, I feel now we have no choice but to move to dismissal on notice on the grounds of performance. So the dismissal letter made it very clear it was a springboard from that final written warning. Now, in terms of the process here that the EAT considered, they applied the same ground rules that would have been applied in a conduct final written warning process. So flicking back, we've got Davis and Wincanton. Wincanton is a more recent case where President Langstaff, as he was, set out, I think that there are 5 or 6 different guidance points that need to be considered when considering whether a tribunal can, the phrase being, look behind a final written warning, look behind a previous warning. Those were applied by the EAT in this case. They also applied some instruction from Bandara as well. And there are 3 points that really I would emphasize here. And it's this idea of it being manifestly inappropriate. So a final written warning may be found manifestly inappropriate if there was something about its imposition that once pointed out shows that it was plainly or ought not to have been imposed. The latter test was satisfied in the case of a warning for gross misconduct, for example, where the conduct was plainly not gross misconduct, and particularly if it wasn't even covered within the respondent's own disciplinary process. A final written warning, this is point 3, will never be manifestly inappropriate if it was within the bound of reasonable responses, although the 2 tests are not the same. And of course they're not the same, because the band of reasonable responses, as we know, is a very fact-sensitive thing. The onus is on the employer to prove that. Manifestly inappropriate is totally different language. Now that's a much higher bar, and that's again in terms of conduct cases when it comes to written warnings. That's described as being a high bar, a difficulty for a claimant to get around. Let's have a look at what the EAT concluded. Now, the EAT's position was that the reasonableness in all the circumstances of this dismissal and not the reasonableness or appropriateness of the final warning, that was a relevant factor, but not the only factor. So in other words, When it comes to unfair dismissal, as in conduct type warnings, the test is still the same. The starting point is not the reasonableness of the earlier warning, but the fundamental question is the reasonableness of the dismissal. Now, obviously, if the earlier warning was unreasonable in some way, or was outside the band of reasonable responses, or was wholly manifestly inappropriate, dismissal is unlikely to be appropriate or reasonable if it flowed from that. So the analysis of the final written warning is always going to be relevant, despite the high bar. Capability or conduct. Now, this is an interesting point put forward by counsel for the appellant in this, which is to say, well, hang on a minute, there's a fundamental difference between capability and misconduct. If we look at the policies in play, the disciplinary policy, in fact, the ACAS code, as we know as well, makes a big deal about warnings. The ACAS code says serious misconduct, even serious misconduct, will not necessarily mean dismissal for a first offence. That's why we have warnings. It's gross misconduct where that would step over the line in a sort of one-off case. But the ACAS code, when it comes to disciplinary and conduct, envisages a series of warnings. In a capability procedure, it's different. There's different language used. You don't talk about warnings per se within a capability process. You talk about reviews. You talk about a final review, maybe. So the argument was that the employer brought in conduct type language by way of final written warning where it should not have been, in other words, into a capability process. It was an interesting argument. However, it didn't win at the EAT. A flexible approach was allowed to have been used by the employer in this circumstances. And really, the differences in language were not material. The employee knew exactly what was required of them, whether or not that was called a warning, whether or not it was called, this is your final review chance. Didn't really make much difference in the circumstances of that case. The 3-month review process was very, very clear. Now, in terms of going behind a warning, this is always going to be, I think, a difficult one for claimants to run, because on the one hand, although President Langstaff in Wincanton says, well, of course, if there's a fundamental dispute about the genuineness of the warning, for example, say there was manipulation as part of the process, then the tribunal is likely to have to adjudicate on that if that's a key part of a claimant's argument. But going beyond that, if a warning is there, it's going to be difficult for a claimant to overturn that unless they've got something seriously good to show that it was manifestly inappropriate in the circumstances. And I think that's fundamentally what sunk the claimant appellant in Falahali, because he wasn't able to meet that test. So I don't think there's really anything I need to know other than to point out maybe the last one bullet point there, discretionary language. So touching again on that point about the capability process in compared to the conduct process, misconduct disciplinary process. In the employer's handbook, where it contained these policies, there was discretion, and the discretion enabled the employer to opt not to take certain steps in certain circumstances. Now, that will differ from case to case. Some disciplinary codes and capability codes within an employer organization will not have that sort of language, will not give the employer discretion to mix and match processes or to act differently when the circumstances arise, particularly if you're in a heavily unionized workforce, for example, or a very large employer, perhaps. But in this case, it was an important thing to point out that the discretionary language in the policy allowed the employer essentially to do that, and it assisted the tribunal bridging the gap between a conduct sounding type warning and a capability type one. So that's a bit of a tip. If you're in this type of situation, look very, very carefully into the wording of the policies that are in play within the employer organization and check out if there is true discretion within that to move on. Now, the next two cases I'm going to deal with very, very quickly for the sake of time. A phobia we'll all be aware of because it's well-known EAT and Court of Appeal authority about the burden of proof in direct discrimination cases. But interestingly, over the summer, the Supreme Court put the final nail in the phobia coffin and very much affirmed and reaffirmed the orthodox position when it comes to the reversing the burden of proof in discrimination cases. And the issue really was whether or not it's right to say that there's an onus, a burden on the claimant to prove that prima facie case before the second stage in the test is considered. In other words, if the claimant fails to cross that hurdle, that's the end of his case. So that's quite a big deal, because one of my favourite EAT judges, as she was, Mrs. Justice Lang, she gave the EAT judgment in Afobe, and she made quite the compelling point that it's essentially not good enough to impose this burden on a claimant at a first instance, and that it doesn't allow the UK and English and Welsh employment law to sufficiently protect those that might be the victims of discrimination by putting this burden on the claimant to prove a prima facie case. And her judgment in the EAT, although unfortunately now has been completely ripped to bits, is still quite compelling from a sort of policy point of view. But of course, by the time it got to the Supreme Court, and this key idea about the interpretation of the statutory material, that had been well decided against that view. And the reason that I'm pointing this out in terms of its Supreme Court authority is that that's not going to be changing anytime soon, because the Supreme Court has had its say, and it is not foreseeable in the near future or even the middle future that this point will be run. So I think we are where we are in terms of the orthodox position. Now, the facts on Afobe that were relevant was that the respondent, the Royal Mail, didn't bother producing any evidence from the direct decision makers in the case. The case involved the claimant, who was an IT professional but was working as a postman and wanted to get promoted within Royal Mail. For a period of about 4 years, he sent 30 separate applications for IT jobs within Royal Mail and didn't get any of them. He was an Irish national who identified as Black Nigerian man, and he alleged that there was direct discrimination against him somewhere in the process that was fouling up his applications because he had the qualifications, etc. That was his case. Royal Mail, in terms of witness evidence, only produced 2 members of the organisation that had knowledge about the general process when it comes to applications, but did not produce direct evidence from those that would have made the decisions in play. You might say, well, how are they supposed to do that? Going back over 30 applications over 5 or 6 years. Okay, there might be logistical issues there, but nevertheless, as you can imagine, the tribunal weren't necessarily that pleased with the fact of the decision makers not being there as witnesses. And I don't know if you've had a case like that. It can be very, very difficult for a respondent where the decision maker isn't available, or for whatever reason isn't there, and you produce a HR manager perhaps, or you produce another type of senior manager, but really that evidence is only ever going to be third hand, isn't it? That evidence is going to be saying, well, this is what should have happened in the circumstances, this is what usually happens, not quite the same as this is what happened. So you can see why the claimant would have had a degree of momentum behind having a plausible case here, because of the lack of evidence on the other side. But because of this first hurdle, that's where the case fell down. Essentially, was the tribunal able to make adverse inferences at that first stage that could have allowed the claimant to go over the hurdle without the respondent witnesses being there? In fact, on the basis of the respondent witnesses not being there. So the EAT decision of Mrs. Justice Lang allowed the appeal. But in the meantime, before Afobe got up to the Court of Appeal, CityLink Limited was decided by the Court of Appeal on this same point and upheld the old 2-stage test that had been in place since Section 54A of the Race Relations Act from 1976. That 2-stage test, which requires the claimant to firstly prove a prima facie case, not only that they've been treated less favourably, but secondly, that the reason for that treatment was the protected characteristic. Before you even look at the second element of the test, which is the explanation from the employer. So the central point for the Supreme Court when dealing with this appeal was Section 136, subsection 2 of the Equality Act requires the Employment Tribunal to consider all the evidence from all the sources and not just the claimant's evidence, so as to decide whether or not there are facts that could show. So that's the phrase, facts that could show that discrimination was happening. The question there is, can you therefore use the reality, I'm avoiding using the word fact, the reality that the respondent hasn't offered any witness evidence about the dismissal, for the ET then, at first instance, to make an inference that there are facts that could show that discrimination was happening in order to clear that first hurdle. So the argument was that replacing the words from the Race Relations Act, where the complainant proves facts, by if there are facts created, so that if is section 136.2, created the possibility for a different misunderstanding that there is no longer any burden of proof on the claimant. And it was argued in the Supreme Court that an analogy here is unfair dismissal, where there's a neutral burden of proof if you get to the section 98.4 analysis in the Employment Rights Act as to whether or not the dismissal was reasonable or not. The initial burden is on the respondent to show a potentially fair reason, but then the burden becomes neutral if that burden is discharged. And the argument was in the Supreme Court, well, why the difference? Why shouldn't there be a neutral burden at that first stage rather than the onus being on the claimant? Isn't that unfair? Isn't that going to be a block on potentially valid discrimination claims? Well, in terms of how the Supreme Court dealt with this, they went for the orthodox line. And they went, no, we've got clear authority here, which has maintained the two-stage process for decades now, almost from the dawn of discrimination, anti-discrimination legislation in this country, almost going back to the genesis of that, Race Relations Act, etc. No, we're going to stick with this orthodoxy, and ultimately it's on the tribunal at first instance to be the fact finders, and more than just fact finders, but also the inference makers. So a phobia at the Supreme Court, I think, is going to be the final nail in the coffin to any suggestion that the claimant doesn't have that burden on them to prove that prima facie case. There's a practice point that flows from this, though, of course, which is, what if you're in a situation where the respondent isn't offering anything by way of disclosure, by way of witnesses? Is it enough for the respondent to simply sit on their hands and say, well, it's for you to prove it at first case? I can just sit on my hands and wait. And then if you get over that hurdle, then I'll bring all my big guns to bear in terms of explanation. But I think that although that is not on the case law that we've seen, going to be an illegitimate way for a respondent to behave, although you might think it's a very risky way for a respondent to behave, the onus is still on the claimant. As a matter of law, the onus is on the claimant to make those facts known to the tribunal. So if the respondent is sitting on their hands, what do you do as a claimant? Well, you get proactive. The onus is on you as a claimant then to seek disclosure, get early disclosure of things. And then, having made those sort of applications, you can say to the tribunal, well, we did ask for the disclosure at this very early stage, and you're aware of that fact, and you're also aware of the fact now that the respondent has refused to provide it. You're in a much better place then as a claimant to invite the tribunal as the ultimate arbiter of fact and inference to make those inferences in your favour. So I think that's the practice point really for that. Even though it doesn't change the law, it affirms the orthodox position. And I think that's helpful because it makes it very, very clear to claimants and respondents what the test really is going to be. Now, lastly, and I'm going to deal with this very, very quickly, just really to flag it up, Seacombe and Reed, another judgment of Judge Taylor. There he is again, 3rd of August 2021 in the EAT. Issues in relation to this case are about disability and knowledge of disability as well. Very brief facts in relation to this. The claimant had suffered with mental health episodes in what you might call his former life, in his period of working prior to working for the respondent in this case. Each of those instances of mental illness had included depression and anxiety. But in terms of the medical records, they were sort of bookended. There was an incident in 2008 when he suffered with depression and anxiety, but then there was a sort of gap in between that until 2015 when he suffered with another bout of depression and anxiety. When he started working for his new employer, the respondent, he was asked to fill in a medical questionnaire, as often new employees will do, and an equal opportunities questionnaire as well. And on neither of those documents did the claimant indicate that he suffered with a disability or any sort of mental health impairment either. He didn't mention that he'd suffered with them in the past. So there's an obvious knowledge point there, which I'm not going to really go into very much today. I'm looking at more this issue of definition of disability. This is a very common question that we come across as practitioners. Now, in terms of your thinking about this, I don't know if you share the same view as mine. We know, don't we, that just because there might be different periods whereby it might be said that a claimant is suffering with depression and anxiety, for example, and there's a gap in between, that does not mean that the person isn't disabled for the entirety of that period if it's essentially a flare-up of something which is underlying. The question is always going to be about likelihood, whether that likelihood is the likelihood that the mental health issue is going to flare up again. And if that is the case, then potentially disability can be established for the entirety of that period. So we know that. What about, how does that apply to this case? Well, this was a judgment of Judge Roper sitting down in Bodmin in Cornwall, and he held on the evidence that the claimant was not a disabled person for the critical reason of him failing to establish that it was a long-term impairment. And as we know, that will always be part of the test. So when it came to the EAT, again, reiterating the point that we know, the ET being, at first instance, the arbiter of fact, this had to be a perversity appeal because it was on the basis of an analysis of the evidence that was before the tribunal. There wasn't an argument that the first instance judge had made an error of law. This was, we don't agree with the factual findings that the judge has made. And as we know, that can always be difficult for an appellant, a bit of an uphill battle when it comes to perversity. Seacombe and Reed is fundamentally not going to be groundbreaking. It's not a new area of law that's suddenly been carved out. But what it is, again, as is consistent with Judge Taylor's judgments, in my opinion, it's a really useful analysis of where the law is when it comes to both disability and knowledge. Now, in terms of the facts of this that are going to be the most relevant, the claimant flagged up for the very first time in January 2008, just prior to his dismissal in March 2018, that he was suffering after a traumatic event that had happened in work, and everyone accepted that he was going through psychological and emotional recovery from that. Now, that's what he said to his employers back in January. On his claim form, he perhaps over-egged the pudding, and this can be an issue when it comes to representing claimants on the issue of disability. It's a difficult line to tread sometimes, because in his claim form, he said that he was suffering at that time with severe anxiety and depression. But the language that he used to his employer at that time did not include that sort of diagnosis. And there was no medical evidence to support that height of diagnosis either. The reminder from the EAT was that when you look at the long-term effects of things, the long-term question is always about the effects, not the name of the impairment itself, always about the effect. And this key point, again, which has been adjudicated recently in the case of All Answers, which is perhaps the greatest case name ever, where it really stresses this point, which again can be difficult for claimants from an evidential basis, that the relevant time in question is going to be at the time of the acts complained of. That means, although it can be it can jar a little bit when it comes to the evidential basis, the evidence that was available to an employer at the time of the acts complained of is going to be the relevant evidence when it comes to the question of disability. And how that plays out in terms of long term, of course, is a real sticking point potentially for claimants, because if in January 2018 he was saying, I'm recovering from a psychological bit of trauma, and then when the case comes through to first instance tribunal, maybe even a year later, and by this point the claimant hasn't recovered, and in fact he's worse because he's been dismissed and he's suffering from depression and anxiety because of all of that, and he's got a huge amount of medical evidence that post-dates his dismissal that shows, yes, this depressive episode was really bad. We didn't know it was going to be so bad in January. but he's been suffering with it for over a year now. You can fall into the trap sometimes of thinking, oh, well, there we go. That's the long-term question sorted. But absolutely no, that's not right, because the question is, when the dismissal happened, or when the detriment happened, or wherever it was, when the victimization happened, what was the evidential position then? And it's actually irrelevant what happens afterwards in terms of medical evidence. And this is, again, from a practitioner point of view, what about expert evidence? So an expert that comes on the scene, maybe ordered a case management conference a year later, and there's a joint expert instructed to look into the issue of disability. The expert's hands are going to be tied by the medical evidence that was contemporaneous to the factual detriments complained of. It is not enough for the expert to say, well, I've interviewed the claimant and he's really bad. He's definitely depressed. He's definitely anxious. And this has been going on for 12 months or more. That is not enough, because unless that expert can say, yes, and at the time when all of this was happening, January through to March 2018, when that was happening, there would have been a strong likelihood that all of these symptoms would have been in play, and that the prognosis would have been for it to go on for longer than 12 months. Unless an expert can say that, then it might not be worth the paper that it's written on. It might actually be better to not even bother going to the expense of having an expert if you know that the medical position at the time contemporaneously is not going to assist them. It might just literally be a waste of money. So, that's a really big deal. And like I said, it can be a little bit counterintuitive, because you think, well, the long-term question is going to be answered by what happened next. No, actually, the opposite is true. All answers confirms that, as does this case. So there we go. Conscious that we've rattled through a lot of those cases very, very quickly. As we said from the start, be really happy to pick up any questions that you might have arising from that. You can email us. There are emails on the screen. If you have questions in the chat, then please feel free to do that. I note that we do have a couple of questions as well, which we can pick up now. We're also very conscious that people might need to fly off and start their working day from their offices or wherever. So please feel free to do that. The session has sort of officially ended now. Thank you so much for being with us this morning. Hope to see you again. We'll hang about for a couple of minutes as well to maybe pick up any questions that come through.
Thanks very much for turning out such great numbers. And I hope you enjoyed your start to your day. And maybe you'll have more exciting things that will happen later on. Obviously, I think it's very unlikely. Have fun, and we'll see if we can answer some of these questions.
Fantastic. Great. Well, thank you for all of the messages and the feedback. We really appreciate that as well. Very kind of you to say. Let me just try to trawl through and get some questions up here.
Let's have a look. Read them out for me.
Yeah. Right, so we've got a question. I think it's going to be to do with the Kong case, Nick.
Yeah.
From Anna, who says, did they dismiss the head of legal or just the head of audit?
No, they dismissed the head of audit. That's the whole point. And the whole rationale of that case is that they decided that because of the dysfunctional relationship between the two of them that was brought on by the behaviour of the head of audit, that the head of audit had to pay with her head. Mm. And that was a claim brought under 103A of the Employment Rights Act. And again, really quite an astonishing state of affairs. But the 2 points being fundamentally, and it was, the word dysfunction wasn't actually used, but it was a question of dysfunction. The fact that she had raised her complaint, her concern about the lawfulness of the document prepared by head of legal in such trenchant ways was the underlying cause of the dysfunction, which was then the reason for the dismissal. And it was the three senior people. There's a very clear unfair dismissal under 98.4, but the three senior people decided that you simply cannot talk to the head of legal that way, question her integrity over a technical issue in the way that she did. There was a meeting between the claimant and the head of legal, and the head of legal stormed out and she slammed the door. Her behaviour was not exactly beyond reproach. And there is no doubt there was an awful lot of ego in play here as well. But the fact is, head of legal decided she could no longer work with this person and refused mediation. So in those circumstances, you might think it was somewhat surprising, but the tribunal concluded the underlying reason, the reason why the head of audit was fired was because of the fact that head of legal could no longer work for her, not the reason which underpinned that. The but-for test, had it applied, would clearly have found in favour of the claimant. The reason why test, which is why we have to look at it so carefully, found against her. Yeah. And I think the point in the EAT in Kong was that the tribunal had taken very great care in reaching that decision, analysed the factual matrix extraordinarily carefully, and made the findings that wholly justified that fine line distinction. Sometimes in these cases you see clear air, a great big gap between the underlying grievance, complaint, disclosure, and the reason for the dismissal. Sometimes there's a fag paper between the two of them, and this is a fag paper case, but nonetheless one which is justified on the merits and one which the AHC couldn't interfere with because the tribunal of fact had made such clear and defined decisions about it. Yeah, so a fascinating case and one that sails close to the wind. Yeah, it all brings a very important point. You've got to win these cases at first instance because trying to appeal them, is going to be very difficult. John Hand, in the early decision in the Woodhouse case, was very, very coruscating about the findings of the tribunal. And his focus is heavily on the whole idea of protection of the victimisation laws themselves. And the tribunals will have to tread very, very carefully and make very careful findings to avoid these appeals. But as I say, get it right first time. Otherwise, it's going to be much harder in the appeal tribunal or above to get home on it. But yeah, I'm sorry I didn't make that clear before. But yeah, unusual case. You'd have thought you had a winner there if that came walking through your door, wouldn't you?
Well, I think that it reiterates that it's always going to be a high hurdle to get over as a claimant, where you are trying to get a automatic unfair dismissal case over the line. So whether that's Section 100, Section 103A, health and safety or whistleblowing, because where you have players involved that are not the decision maker, getting their actions or their manipulations, sometimes called the Iago type cases, isn't it? Yeah. From Othello, getting their actions to be also the actions of the employer, because of course it's the employer that dismisses. That is a very difficult divide to get, apart from in very express circumstances. That's why, from a practical point of view, you want to be running detriment claims, isn't it?
Oh yes,
it's absolutely. A lower threshold, and you can identify the individuals in play as well, and then the employer can be vicariously liable for that. So, and I think it was a time point, wasn't it, that they didn't run a detriment claim because they were out of time to do that.
Yeah, and you make a very good point about detriment claims. The threshold is very, very low in real terms. You just have to show a substantial connection between the matter complained of and the detriment suffered. But obviously, with any automatic unfair dismissal, it's to be the principal reason for it. And but really, the focus on this slide in respect of the Kong matter, in submissions on this case very recently, differing lines, a judge indicating a concern that this was bang on the facts of the case before the tribunal. And actually arguments that this really doesn't develop the line of jurisprudence. It's just another example of the same sort of thing. But the truth of the matter is, if you do have a falling out in a senior position between senior people, that in itself can be a very good reason for one of those people to go. And that, if as long as the tribunal makes the finding that it is the falling out that is the reason for the departure, not the underlying cause of it, again, we're back to this whole debate about the but-for versus the reason why test. Don't fall into the trap, very easy to do, of assuming that because someone's blown the whistle, raised a complaint about discrimination or raised a matter that gives rise to a claim under any of the automatic unfair dismissal jurisdictions, that is going to be the reason for their detrimental treatment and or dismissal. Yeah, interesting line. But as I say, the side text to to the Con case was very clearly a further review of the Jehuti case. Jehuti was obviously a fascinating case in the sense that the reason put before the disciplinary panel was manufactured, and they were literally the subject of as Geraint referred to it, in the Iago figure.
Yeah.
There are going to be other examples where that bar is less high, but I think there's an argument for saying Jehuti is decided on its facts. There are some broad guidance principles given in Jehuti by the Supreme Court, but there are going to be many more examples where there's an element of clear manipulation. For example, in the management of a trial of the bundle put before a disciplinary panel, or the choice of witnesses that are called to the panel, for example. Of course, nothing to do with the existing case. But the truth of the matter is there may be ways in which you can manipulate an outcome without manufacturing an entire pack of lies, as was the case in Jehuti. That's going to be a fascinating area of development of the law in the next 5 to 10 years, I think.
Yeah.
And no doubt about it, when the matter was argued in the Supreme Court, the preceding case of Orr, which was a case that sought to limit these sorts of arguments, once the lid was taken off that, it was the lifting of Pandora's box in terms of these sorts of arguments. And another perfect example why employment law is so awesome, because it's constantly changing and presenting us as lawyers with golden opportunities to make new arguments and take things forward.
Absolutely. I always remember Orr because it's the orthodox position, isn't it? So it's the Orr orthodoxy. And I think we haven't seen the end of that run because working worlds are complicated and people will sometimes try to manipulate situations to get their ends that they want. And we're always going to have these arguments. The difficulty for claimants is going to be just to put that nebulous action onto the shoulders of the employer, not by a vicarious liability way, which you go through detriment, but through actually under the statute's provisions within the unfair dismissal remit onto the shoulders of the employer in terms of making their decision. Now, in terms of just a couple of other things, I don't think there's anything substantive question-wise, but a couple of practical questions. I can see that Victoria has asked about a recording of today and Lizzie has asked about PowerPoint slides. What we will do, because I actually don't know the answer about the recording, our IT guy deals with that and I'm definitely not allowed to go anywhere near that, otherwise he'd kill me. So if you would like a recording of today or are interested in that or interested in the PowerPoint slides, we'd be very happy to provide those to you. And what I would suggest is you just email either me or Nick and we can pass that on to the powers that be. But other than that, if there's nothing else, I think we're going to end our live stream today. Just to reiterate, thanks very much for being with us and for turning up this morning, and I hope you had a good time.
Thank you. Yeah, see you soon. And by the way, if there's anything else you'd like topic-wise to raise as a potential for a future Breakfast Bites or seminar, let us know. We're very interested to know what you think you'd like to hear about. So, but anyway, again, many thanks for coming, and we look forward to speaking to you by email or phone, whatever. If you have any questions, you want to just pick the phone up and have a chat about a case, give us a bell. Speak to you soon.
Absolutely.
Take care.
So long.